First of all, thank you for coming. You are officially the largest audience assembled at the JLF today. You can tell that you're sort of spilling out into the audience. I can't think of very many people who could get this kind of crowd. Maybe Taylor Swift, which is actually appropriate because my guest today is India's #1 Swiftie, a great Taylor Swift fan. Brief thing, I was going to call him Chief or Chief Justice. He's insisted that he shouldn't be called that. I know him a little bit, and I have a slight insight into his personality because I know him outside of the legal fraternity. We were once judging a scholarship together, and he was, I think, Chief Justice of the Allahabad High Court, so not necessarily a household name in those days. And one of the lawyers we interviewed for the scholarship gave examples of bad judgments. And one example she gave was the Vodafone case in the Bombay High Court. She did not know that the author of that judgment was on our panel. And she tore into the judgment. And she said it was badly thought out, it was wrong. And I felt really sorry for her. And I said she's had it. But afterwards, when we met to discuss who the winners were, Justice Chandrachud said to us, look, the points she's made are the worries and the doubts that I have had. She doesn't agree with me, but the arguments are very sound. We should give it to her, and we gave it to her. That tells you something about the kind of man he is. You're really a Taylor Swift fan? Or this is just a myth?
Yes, no. Well, Ophelia is a big favorite.
But it's not exactly your generation, Obo, is it? No?
Well, I belong to the baby boomer generation, but I have two daughters who are special needs children who are Gen Zs. So, if I have to be relevant to their lives, I have to follow what Gen Z is doing.
Because we're actually talking about a book of speeches rather than a sort of strictly legal book. And I was reading it and I was looking at the references. There's lots of the stuff you'd expect, from the US Supreme Court, the Indian Supreme Court, philosophers like John Stuart Mill, Kant, etc. And then there are lots of quotes from Bob Dylan, Leonard Cohen, Harry Potter. You read all this stuff.
Yes. I remember the Len Cohen quote, when I was writing the judgment decriminalizing homosexuality, I thought that this had to be a judgment with a flourish. There are some judgments which you write, in the middle of the road, and some judgments where you lend a bit of flourish. And I found this brilliant, song by Len Cohen. And so, but, that's part of...
What was the quote?
Democracy is in danger, it said,
I remember that, yeah. Okay, so let's start, and I'm going to start with a vaguely hostile question because, there is a crack in everything. That's how the light gets in, as you will understand. So let's start with liberalism and democracy. Many people in the audience feel that liberal values have never been in as much danger as they are today. They will say that to your face, and they will say behind your back, it's people like Chandrachud who did nothing to stop it, that liberalism is in danger because the Supreme Court didn't do enough. Well, now, wait for the question. This was just the insult. Now wait for the question. The question is, the cases that are usually cited to prove this, and this has happened after your time too, is say Omar Khalid. Why should this man be in jail 5 years later with no kind of trial, with nothing? I know you've commented on it before in your time, but I don't want to mean this just as a criticism of your Chief Justiceship, though perhaps it is. I mean it as a general issue about the Supreme Court as a whole. They've again denied him bail. Can you explain what the Supreme Court's position then is, now is, or what the legal position should be?
I now speak as a citizen and not as a judge.
Absolutely.
I also begin by telling you that you can have the wisdom of hindsight. And it's easy to have the wisdom of hindsight because I've left the court. But on this particular case, let me make just the law as demystified as possible and then answer the question.
Okay.
Bail before conviction should be a matter of right because our law is founded on one presumption, and that's the presumption of innocence. That is, every accused is presumed to be innocent until they are proved guilty at a trial. The second, pre-trial bail cannot be a form of punishment. Because if someone is in jail for, say, 5 years or 7 years as an under trial, and then is finally acquitted, how do you compensate for the lost time?
Yeah.
When do you deny bail to an accused? I'll give you a very simple example, and then answer your question.
Okay, go ahead.
Suppose you have a serial rapist and a murderer who has been arrested on the allegation that that person has committed, say, 6 or 7 rapes and murders. There's a danger that if you let that person out into society, that person might repeat the offense.
Yep.
So this is a classic case where you would deny bail, where there is a danger that a person after being released on bail would commit the same offense. Second, a second exception, where a person on being released on bail wouldn't be available to face trial, that is, leave the Indian jurisdiction and escape out. That's a valid reason to deny bail. The third, a person who would tamper with evidence at the trial. If these 3 exceptions are not made out, bail has to be the rule. Now, the problem which we are facing today is this. A lot of our laws, particularly those relating to national security, have turned the law on its head by substituting the presumption of innocence with almost a presumption of guilt. Now, what does a court do when the state says national security is involved? And there I believe that the court is duty-bound to carefully scrutinize as to whether national security is involved, and second, whether the detention of the accused is proportional to the plea for national security. Otherwise, what's happening is this, is that you find people being incarcerated for numbers of years. And final point which I want to make, and which will really then put my answer in perspective, is that one of the serious problems of the criminal justice administration in India is the inability of our prosecutions to conclude trials within a reasonable period of time, which means that the prosecution is not going to be completed within, say, 1 year or 6 months or 3 years. If that is so, you have one fundamental right which is at issue. The right to life under Article 21 includes the right to a speedy trial. And even if an individual law denies the right to bail, as many of our laws do today, so the Narcotics Act does that. The Constitution is the supreme law of the land. Laws enacted by Parliament are tributaries which follow from that source. And therefore, ordinary laws must yield to the Constitution. And therefore, I'm very clear in my mind that unless the well-settled exceptions are made out in a particular case, the accused is entitled to bail.
Okay. I think that's a great argument. I don't think anyone here would disagree with that. But I have just 2 words. Omar Khalid.
Look, they've been inside for 5 years.
Yep.
I'm not criticizing my court. You can understand my hesitation in criticizing my court because I was part of the institution which I was leading just last year. Each one of these principles which I have mentioned does point to the fact that you can impose conditions to ensure that the conditions for bail are not abused, but you must necessarily take into consideration that they have the right to an expeditious trial, and if an expeditious trial is not possible under present conditions, then bail should be the rule and not the exception.
It sounds a lot to me like you're saying you would have given him bail if the case had come up now.
Well, you know, it's wrong of me to presume what I would have done if I was sitting there.
Come on, answer the question. Okay.
You know, it's easy to sit outside the court.
Yeah.
Having said this, you know, judges, let me also be fair in the court. Judges have to look at the record of a particular case and then see what kind of evidence there is, what kind of material there is before the court. So therefore, I think I would be, as a judge who has sat in the hot seat for 25 years, be slow to criticize merely because I have a difference of opinion on this one.
Difference of opinion, i.e. you don't agree. I think you've just given yourself away with that phrase. Yes?
I just made my point.
All right, okay. I think we've got that. But let's talk generally about bail. Omar Khalid is a celebrated example. But Your court has had a mixed record. You've sometimes been very good on bail, haven't you, when you were there?
I think we have. In fact, during my period of 24 months, we disposed of about 21,000 bail applications. And I must tell you that there are cases which people don't think about when they criticize the Supreme Court for not granting bail in a particular case. And I'll give you just two illustrations which come to my mind straight away. There would be probably many more. You've probably heard the name of Pawan Kheda.
Yep. The Congress spokesperson.
Yes. Pawan Kheda said something which I believe none of us in the audience would say about some other person's parentage, be it a political leader or anybody else. He was about to be arrested. He was boarding a flight, I believe, at Guwahati, and he was about to be arrested. The paramilitary forces had surrounded his aircraft. His lawyer came and mentioned before us, soon after we assembled after lunch, that he's about to be arrested for having said something. The lawyer said that this is unforgivable. It's uncivil, but it's not a case for arrest. And we protected him against arrest. That was a leader of the opposition who had said something which was uncivil, but everything uncivil is not something which is an offense under our law. And we protected him against arrest.
And the person he'd been uncivil about was actually a very powerful person. Is it fair to say that?
Absolutely. And you know who the person was.
Yeah.
That
I
he
think
said
many
that
people
about.
will, but since he's being discreet, I won't mention the name, but think about it.
Example number two. Tista Setalwad was denied bail by the Gujarat High Court, but they gave her time until 12 midnight on a particular day to surrender. The two judges who had heard the case differed on whether she should be granted a suspension of her sentence. One judge said she should be granted suspension of her sentence, which meant that she would get bail. The other said no, she has to go in. The matter came up to me as Chief Justice of India when I was attending a music recital of one of my colleagues' daughter in the evening. And I said, this is a case, I was criticized for it, but I said, this is a case where she's entitled to be heard. Whether she gets bail or not is for that court to decide. We constituted a bench at 9 o'clock in the night. That bench decided, a 3-judge bench, a larger bench because 2 judges had deferred, and she was granted bail. If we had not done that, if I had not exercised my administrative powers, she would have had to surrender at 12 midnight, and which meant that she would have gone in for probably several months, or we don't know how long. So, these are the kind of cases which don't necessarily see the light of the day because it's very easy to be critical of those cases where you defer with the Supreme Court. Can I give you one last example?
Yeah, sure.
There was this individual. I'll tell you the name of the individual at the end. This person was charged with having committed electricity theft of electricity cables and equipment. So you can imagine somebody from the margins of our society. Otherwise, who would go on the road and commit a theft of electricity poles and cables? Now, his problem was that he was held guilty in 9 cases on the same day. In each of those cases, he was granted imprisonment of 2 years. His lawyer didn't tell the court that please allow for the sentences to run concurrently, which means that all of the sentences run together. Suddenly, he realized that he will be inside for 18 years for electricity theft. He went back to the Allahabad High Court. The Allahabad High Court took a legal view saying that, look, you agreed to this sentence. It was a plea bargain. How can you turn around and come back and challenge that? He came to the Supreme Court and we said, look, personal liberty is a valued fundamental right. And you can't certainly ask an individual who is guilty of this kind of an offense, to go inside for 18 years, more than what ordinarily a person would if he committed murder. Now, I'll tell you what the name of the person was. His name was Ikram. So I just thought I'd mention this because the grant of bail, the grant of relief by the Supreme Court is agnostic to faith, to caste, to gender. Yes, you might have a difference of opinion with the Supreme Court on individual cases. That's bound to happen because you have 34 judges, 17 benches. They called us a polyvocal court. And when there are different people with different backgrounds, different life experiences, different ways of looking at cases, there are bound to be differences of opinion. But that's why our system is so vibrant, I guess, and does have its imperfections. And we live with imperfections in our institutions in a democracy as well, and try and improve upon them for the future.
You've said, and I think that's probably accurate on balance, that the Supreme Court's role and its record on things like bail is not as harsh as people seem to think. It is not as bad at all. There's much more to it. But I noticed you said Supreme Court. Let's go down in terms of high courts and particularly lower courts. Isn't there an increasing tendency not to give people bail?
I think you're right, and that's a matter for concern.
Yeah.
Because the first point of interface of our citizens is with the lower courts, the district judiciary. Now, why are district courts reluctant to grant bail? And we must understand that. The reason is because, we have developed a culture of distrust in our country, a general distrust of authority, and therefore judges, particularly at the lowest levels, have a sense of all-pervading fear that if I grant bail, would my motives for the grant of bail be questioned? Sometimes you may have an offender who is, alleged to have committed a serious financial fraud of, say, 20,000 crores. And the judge feels that, well, if I grant bail, will my integrity be called into question? Because all too often now we are willing to cast aspersions on people in authority. And this is one classical case where judges of the district judiciary feel that it's better for me not to grant bail and allow for a higher court to grant bail. But look at how the system is becoming dysfunctional as a result. Cases which should end in the grant of bail in the district court have to travel to the high court. The same thing happens in the high court. Cases where the high court should be granting bail land up in the Supreme Court. The net result is that the Supreme Court is dealing with 70,000 cases in a year, not bail cases, but overall 70,000 cases in a year. No Supreme Court, except perhaps the Supreme Court of Brazil, deals with these kind of cases, this volume of cases. But how do we answer this general culture of distrust for public authority? That's a problem. I don't have an answer for it. But that's the reason why there is a general reluctance on the part of, but there's something which decision makers can do. Say if a district judge grants bail wrongly, and you feel that, he shouldn't have granted bail, say in the case of a bride burning case on dowry, you feel that the husband is clearly, there's prima facie evidence to show that he and the wife were the only two occupants and she was burnt. Who else would burn her? And there's allegation of dowry harassment. The district judge still grants bail. You want to reverse the bail. Fair enough, reverse the bail and say this man shouldn't be granted bail today. But don't cast moral aspersions on the district judiciary, because by doing so, you're creating a broader ecosystem where people are fearful of exercising their duties under the law courageously.
Yeah, I think it's a very good and valid point. But the other side of this characterization of judges are scared of being called corrupt, etc., is that you're portraying the lower judiciary as little mice concerned about their reputation from under attack from all of us. But it's not true, no? There is a fair amount of corruption. There is a fair amount of corruption in the judiciary.
But they're not just fearful of the attack by civil society. You see, a small observation by the High Court in regard to the conduct of a trial judge would completely destroy the career of the judge, because their promotions depend upon how they are assessed by higher courts. And that is an issue on how we assess the judges in the trial judiciary. So the problem is, it's not a problem about just an unwillingness to grant bail per se, as opposed to, how we actually treat the entire ecosystem of the Indian judiciary, how we assess people whose performance comes up for consideration when, higher office it beckons them by virtue of their seniority in the institution.
Yeah, I'm actually going to come to that, about how judges are appointed. Yeah. But there was part of the question that you neatly sidestepped, which is that there is corruption in the judiciary, isn't there?
Well, I'm not justifying it, but you must also understand that the judiciary also is drawn from civil society. And can you say that Indian society is absolutely, dyed in the white? Now, that's not a justification for corruption in the judiciary, because people who assume higher office have to answer a higher calling, and that there is an expectation from judges that you will not behave in manners which are inappropriate, which perhaps you might even condone in some other context. But yes, there is corruption in the judiciary. But again, that is exaggerated. Second, I do believe that we need efficient systems to make those judges who are guilty of corruption accountable, because that's in the interests of the republic. So, speaking for myself, it's easy to target a judge because of a wrong judgment by saying that, well, this judgment was delivered for a corrupt motive. But there again, I just feel that, that's part of the ecosystem where people level allegations with a degree of, liberty, but without having regard to the actual truth of the case.
It's not a bit of a cop-out to say, yeah, they're corrupt, but our society is corrupt, kya kare? That's
No, I didn't
basically
say
what your
that.
argument amounts
No,
to.
not at all.
Then what do you
I
say?
said, no, to the contrary.
Then what do you say?
I said that though there is a high level of corruption in society, you expect a higher degree of honesty on the part of judges. I'm very clear about it.
Okay.
And second, that allegations of corruption must be dealt with efficiently within the judiciary. But I've said that, and that you need to reform the system to bring to bear more efficient systems than the present procedure for impeachment to deal with allegations of corruption.
Okay, that gets us into an area I did want to talk about, which is, do you feel at the moment there is no real assessment of people's honesty, that something goes wrong, there's not much you can do? There's been a lot of criticism from the government, though they've been quiet over the last year, of the Collegium system of appointment. Do you think we need to look at the whole thing again?
You mentioned the Collegium system of appointment, and I'll deal with that. The Collegium system of appointment, for those of you who are not familiar with the Indian system, is a system where recommendations for appointment to the High Courts and to the Supreme Court are made by the senior-most judges of the High Court and by the Supreme Court, 3 in the High Court and 5 in the Supreme Court. Now, the allegation, the charge against the Collegium system is that this is really an incestuous system where judges appoint judges. And why can't you have, for a more transparent system for induction of outside talent to decide who should man the judiciary? Now, as a matter of principle, I quite agree in the sort of criticism which, say, you have given voice to, or which you find expressed in civil society, that today the Supreme Court of India and the High Courts are exercising enormous power. The kind of issues which we dealt with when I was Chief Justice of India and a judge of the Supreme Court are issues which will transform the position of Indian society. For instance, my decision to bring women into the armed forces on a permanent basis. That's transforming the face of India, obviously for the better. Decriminalizing homosexuality, creating for a more inclusive society. Ordering, for instance, that, you shall not have caste-based discrimination in prisons. Again, a transformative. But the power, electoral bonds, we struck down the electoral bonds. These are very powerful decisions of the court. Now, when a body of individuals exercises such tremendous power, I do believe that society has a vested interest in understanding how people are appointed to that body. Yep. Now, the problem really is this. As a judge, I was a soldier who implemented the Collegium system. I was bound by the Collegium system, and I speak now as a citizen. I do understand that there is a need for having outside talent to make the process more transparent. But when you talk about having a more independent system, who should then be as part of the Collegium? Would you want the government to be a part of the Collegium? Obviously not, because your answer would be worse than the ill that you are seeking to cure. So you would want an independent body which would constitute the Collegium. Now, the problem is always in the detail. The devil lies in the small print. When you talk about independent collegiums, who will appoint those people? Who will be the independent people in the Collegium? Would the government again appoint the independent members of the Collegium? Then again, you are really only having a Collegium which is labeled as independent, but where the appointing authority is again a political authority. Therefore, we came out with the Collegium system by virtue of which, the judges were expected to be independent, and therefore they would appoint. And I must tell you this, that much of the criticism is really misplaced, because the process of appointing judges takes place at different levels. It is vetted in the High Courts. After the recommendations are vetted in the High Court, they are considered by the state governments. State governments are not necessarily the governments who are in power in the center. The file is then vetted by the Intelligence Bureau for a character check. The Government of India comes back with its inputs, and finally the file goes to the Supreme Court of India. I think the answer to your question at present is greater transparency. For instance, in the case of Mr. Saurav Kripal, whose appointment was recommended by the High Court, reaffirmed twice by the Supreme Court, sent back by the government, and we reaffirmed the appointment and sent it back to the government. And I put out the entire, as a Chief Justice of India, I put out the entire reasons for reaffirming the appointment on the website of the Supreme Court. And we said that, look, the fact that he is gay, that he has a gay partner, should make no difference to his ability or capacity to be a judge of the High Court. And I thought that it's important. Yeah. I thought that, irrespective of whether the President of India, who is the appointing authority, appoints him or not, at least our position as the Supreme Court of India must be placed before the people. The final word is not in our hands on judicial appointments, but our views must be placed before the public. And I think, therefore, greater transparency in the appointment process is perhaps key to generating a greater deal of public confidence. There again, how transparent can you become? Should you be as transparent as, say, the American system, where you have hearings before the Senate? Now, when you're appointing judges, you're looking at a 360-degree evaluation of their personal lives. Sometimes there's a divorce case, serious allegation made in a family context against a judge. Do you put all that dirty linen out for public consumption? If you do that, there's a danger that good people may not be willing to put their heads out and even say yes to accepting judgeship. So there again, there are always two sides of how transparent you should become. But I do believe that reasons for appointment must be put forth in the public realm.
Okay, now let's take you up on this. I think everyone will agree that there's something wrong with the system, but it's the least worst system. It's preferable to the government appointing judges. What we can do is reform and amend the system as it now exists. So what would you do apart from transparency, and how would we do it?
For one thing, I think transparency in the sense, first, the parameters which you apply for selecting of judges must be put out on the website of the Supreme Court. Second, the pool of talent which has been considered for judicial appointment must again be set out in the website of the Supreme Court for appointments to the Supreme Court. Third, the basis of the assessment must be made clear in on the website of the Supreme Court. And on the Collegium, I have another point. Judges who enter the Collegium very often do so for short periods of time. Somebody enters the Collegium for 6 months, somebody will be in the Collegium for a year. But you are making appointments of judges who will be there in the Supreme Court for the next 5 years, 9 years, as in my case, in the High Courts for 17 years. So should you not have a more permanent Collegium as opposed to a shifting body of judges who would be constantly rotating every few months or every few years? That's one thing.
Sorry, more permanent means for how long would the term be?
I would think that you should have a term of at least, say, 3 years to be a part of the Collegium for the High Court.
And the Chief Justice would appoint this person to the Collegium in your system?
I would think that, the independent members of the Collegium should be recommended by the Chief Justice, and the recommendations of the Chief Justice should be placed before the President of India, because you will have to have some element of political participation as well.
Yeah, but you'll end up with the election commission type situation, right? Once you get the government involved.
No, not necessarily. No, not necessarily.
Okay.
You see, not necessarily. The reason for that is this. If the Chief Justice of India is going to make the first, he's going to prepare the pool of independent people who will be part of the Collegium, then give the President of India the task or the choice or the discretion of selecting, say, 3 people. So in the Supreme Court, for instance, you can say that the top 3 judges will be a part of the Collegium, or the top 5 judges can be part of the Collegium, and there will be independent members of the Collegium who will not necessarily be judges. They may be even from civil society, eminent people who have occupied public positions in public life. The Chief Justice of India will prepare a panel of people in consultation, say, with his first 5 judges, place them before the President of India, put them out again in the public realm so people know what are the credentials of these people who are being appointed, and then have some outside input into the work of the Collegium. I think that will lend a degree of public confidence in the process of the work which is carried out by the Collegium.
Did you think of this when you were Chief Justice? Did you try and do something then?
You know, you must, I began by saying this. When you're within the system, you're bound by a system. You have to accept the system. When the National Judicial Appointments Commission was challenged, I was not a judge of the Supreme Court. I felt that the NJAC should have been given an opportunity to work. The Supreme Court struck down the NJAC even before it worked for a single day. Speaking for myself, it was premature. When you are within the system, you have to apply the system and try and work your way around it to the best that you can. I made the decisions of the Collegium more transparent. We would circulate, the judgments, 50 judgments of all the judges who were under consideration to every member of the Collegium. So we were all on the same thought page, basically. So we did a lot of change within the system to make it more objective and more transparent. But when you're within the system, you have to apply the system. You're bound by the system. Yeah. When we stand outside the system as civil society, we can think of whether there is a better system or what are the pitfalls.
But who will make these changes? You were, of course, as we all know, a very liberal Chief Justice. You're out of the system. Someone like you could be appointed to head a commission, and yet you've taken the position that you won't accept any job from the government after retirement.
I'll tell you what. That's a problem. Many of our laws today speak of a retired judge of the High Court or the Supreme Court heading a tribunal. Now, because the kind of backlash with judges who accept post-retirement jobs, the backlash, good people are just not willing to accept those assignments. Speaking for myself, I thought that 25 years of judging was long enough, and it's time to move into civil society. I'm not sure I could have, participated in a discussion like this if I was still in office. Yeah. So the joys of being a private citizen are limitless, and I've just preferred a private life.
Is it true that you turned down things like the Human Rights Commission, etc., which were offered to you? Well, as a private citizen, you can tell me.
Well, we're not having a cup of coffee, are we? Some things are best left unsaid, but as all of you know, I'm here as a private citizen.
But isn't there a problem, Dhananjay? Because the people who can make the changes, people like yourself, say the process is tainted or whatever, or is open to suspicion, won't do it. The people who want these jobs after retirement then give judgments that are inclined to make the government think more favorably of them. So we're caught in this cycle, aren't we?
Absolutely. I mean, civil society has this perception that if you take up a job right after retirement, then maybe some of your judgments were impacted upon the desire for post-retirement office. That may not necessarily be so. One of our greatest judges, Justice Subbarao, resigned from the Supreme Court to contest the presidential election. So, it's not always so.
Which is not quite the same thing as accepting a nominated seat in the Rajya Sabha.
I completely agree. Yeah. Oh, I completely agree. Yeah. I completely agree with you. Yeah. I completely agree with you. Putting your head out to contest a political office, I mean, you're a free citizen. You can certainly do that. But accepting an avowedly political nomination, say like, a Rajya Sabha seat soon after retirement, is something which I would have concerns with as well. Also, I do believe, that there has to be some degree of a cooling off period where people don't associate what you decided as a judge with, the kind of rewards you've got after you retired from office. Governorships, for instance, have been looked upon critically by civil society when retired judges do accept, a gubernatorial assignment. But ultimately, it's for everyone to himself. The Constitution does not contain any bar. So let's be very clear, the Constitution didn't create any bar. I believe it's everyone to himself. But there has to be possibly some informal parameters which judges would lay down for themselves, at least in terms of how much time you will allow to elapse. But again, there are tribunals where you have to have good retired judges assuming office. Today you have particularly in the economic regulatory area, you have some very complex tribunals, the Electricity Appellate Tribunal, the airports, you have the other tribunals, the CSTAT. And you need good judges to man those tribunals, but those are obviously not for necessarily for Supreme Court judges. They are for High Court Chief Justices or High Court judges as well.
I'm going to have to throw this open, but last question. I know the kind of guy you are. You will say, no, you could have done much more. But looking back on your time as Chief Justice, what are your regrets and what are you proudest of?
Should I begin with the regrets?
Always.
Yes. Looking back, I always felt that, your time on the bench is limited. When the Constitution is telling you to go home when you turn 65. So you try and make the best. You lay down your priorities. One of my priorities was to reform the processes of the Supreme Court. My regret is that, I could have dealt with some more cases which I had listed and which I couldn't do. For instance, now I can tell you, today, 75 years after independence, marital rape is still not an offense. A husband who murders his wife is guilty of murder. A husband who grievously assaults his wife is guilty of grievous hurt and can be tried and convicted and sentenced. But a woman who is subject to non-consensual intercourse cannot complain of marital rape. I think that part of the law has to change. That case came up before me. I was left with 2 weeks before I retired. The lawyers, for one side, felt that I was rushing them and that they hadn't been given enough time to argue. I said, I don't ever want to retire with the allegation that I didn't give a fair hearing to one side. And therefore, I said, I'll pass on the baton to the others. For things which I shouldn't be talking of things, for which I'm happy about.
You can.
But
it doesn't matter.
I don't want to be...
We've given you hard enough time. You can take some credit.
I'll not take credit for the judgments which I've written. My judgments are now public property. It's for all of you to assess those judgments. But one thing which I really look back with a great deal of satisfaction is that I tried to convert the Supreme Court into a people's court. No case was too small for us, and no case was too big. We started live streaming of court proceedings. I was warned against starting live streaming. And I said, let the citizens know what happens in the courts. Let them know how important is the work of the court in the lives of the nation. Let a person, say, sitting in the corner of the Northeast or, a small district in Maharashtra or in Uttar Pradesh, know how their case is being argued by their lawyer. So live streaming took the proceedings of the court to the hearts of the people. Second, all our proceedings are in English. All the 37,000 judgments of the Supreme Court since independence are in English. That's not the language which India at large speaks. So we have used AI-assisted machine learning software to translate every one of these judgments into every language recognized by the 8th schedule of the Constitution. And I think, the Supreme Court in that sense has to reach out to the community, to become part of the life of the community. Because this is not really a Supreme Court of Delhi. It's a Supreme Court of India. And what better way than to reach out to people in their language?
Thank you, Anji. Sorry, can you hear me? Can you hear me? Is my mic working? Yes? All right, great. Okay. If you can hear me over the siren, I think we can take 1 or 2 questions. Anybody the question? All right. So I don't think we're going to do this question. I think it's not working. I'll take this one. There are laws that turn jurisprudence upside down. Can they be challenged?
Bail jurisprudence.
Bail jurisprudence. Can they be challenged? For instance,
of course.
That's one of the defenses you gave for people not getting bail.
My simple answer, because we have to have more questions as well. My simple answer is yes, of course they can be challenged. Just one sentence in response as well. Under Article 32 of the Constitution, where there's a violation of a fundamental right, every citizen is entitled to move the Supreme Court to challenge the provision of a law which is contrary to Part 3 of the Constitution. So you have that right.
Okay.
Changes to the Collegium system, and you said there should be tenure of the members of the Collegium system. But there are instances where the Chief Justice himself has very small tenure. So isn't it good to have
Okay, all right. Okay, I got the question. Okay,
got
if you
the
want, the
point.
question
Yeah,
is
I got the
basically
point.
this. He suggested longer tenures for members of the Collegium. That's okay in an ideal world, but we live in a world where sometimes Chief Justice has a tenure of a few months, etc. So does that fit in?
So my answer to that would be very simple. That, the members who would be picked up as independent members of the Collegium outside the judiciary should be people who should have fixed terms. So they would really be that sense of continuity which would endure for the future.
Okay, I think you can try and get him outside, but we're completely run out of time. There's a session after this. What can I say? DY Chandrachud, thank you so much for being so honest, so outspoken.
Thank you.